Good afternoon. All right, welcome everyone. And so we're honored to have the founding dean of the UCI Law School, Dean Erwin Chemerinsky, with us today. Not only is Dean Chemerinsky the foremost scholar in the United States on constitutional law, but he's recently completed a book with our Chancellor, Howard Gilman, that will be entitled Free Speech on Campus. Thus, we chose that title for today's speech. And who is better suited to speak on the rising issues confronting college campuses regarding free and controversial speech on college campuses? Now, I can go on and talk about his bio and all the wonderful accolades that Dean Chemerinsky has, but I don't want to take more time away from his talk today. But I will share, however, recently the National Jurist magazine named Dean Chemerinsky the most influential person in legal education in the United States. And so it's a great honor. And it's a great honor for our institution to have Dean Chemerinsky advocating on behalf of our students, our community, and on behalf of our Constitution at a very important time. So with that, let's give Dean Chemerinsky a great round of applause.
Thank you so much for the kind introduction and the warm welcome. Thank you for coming to listen today. Issues of free speech on college campuses arise frequently. Let me give you a few recent examples. 2 years ago, in March 2015, a group of fraternity members were on a bus going to a fraternity event. The only people on the bus were members of this fraternity. They were actually all dressed in formal wear. 2 members of the fraternity led the others in a chant. The chant used racial epithets. The chant referred to lynching in a positive manner. It was horribly and deeply offensive. One member of the fraternity recorded it on his phone, posted it on the internet. It went viral. Almost immediately, the president of the University of Oklahoma, David Boren, expelled those 2 students from the university and suspended the fraternity from operating on campus. Assume that those students had sued President Boren and the University of Oklahoma. Should they have won based on freedom of speech? Or was the university justified in expelling them given the racist, deeply offensive quality of their expression? Another example. In October of 2016, a law professor at the University of Oregon, Nancy Schertz, held a Halloween party in her home. About 25 people came. Some were her colleagues on the faculty, some were students and former students, some were staff. She came to this Halloween party in her home in blackface, wearing a medical coat. She later said that she did this so as to express the lack of minority representation in medical schools and in the medical profession. Immediately, there was controversy. Many of her colleagues signed a letter urging her to resign from the faculty. The dean of the law school and the president of the university suspended her from teaching. And in December, an investigation said that it was appropriate to discipline her because her activity created a hostile environment for students that minority students find it difficult to learn in her classroom. Assume she sues the dean, the president of the University of Oregon. Is her speech protected by the First Amendment? One more recent example. On Wednesday, February 1st, Milo Yiannopoulos was scheduled to speak at the University of California, Berkeley. The chancellor there, Nicholas Sturks, expected that there would be protests. So he asked the other 9 campuses of the University of California to loan security officers to come. He was urged by members of the faculty to cancel Yiannopoulos' speech, but he refused to do so. He believed that the First Amendment protects a right to express even outrageous messages. But he wanted to be sure that there was adequate security. Notwithstanding his efforts, the security was inadequate. 150 masked individuals, who, as best we know, self-identified as anarchists, ran through the campus, causing damage. They threw Molotov cocktails that started fires. They broke windows. They cost hundreds of thousands of dollars to the campus. The chancellor, seeing what was going on, believed he could not protect the safety of those on campus, and he canceled the Annapolis speech, saying, though, that the campus would find another time to have the speaker back. You might remember that just 2 days later, President Donald Trump issued a tweet condemning what Berkeley did as violating free speech, saying that if campuses don't protect free speech, they should lose federal funds. If Annapolis or the audience that was there to hear him sued, was the First Amendment violated? What all of these examples reflect is how much issues of free speech constantly arise. They show the inevitable tensions that exist on college campuses. Colleges must provide a learning environment that's inclusive, that's protective of all students. Campuses must protect order and safety in order to accomplish this. But campuses also must protect freedom of speech. How are these competing interests to be weighed? When does free speech triumph? When should these other interests win out? That's what I want to talk about with you this afternoon. As was mentioned, I've the last couple of years co-taught an undergraduate course with Chancellor Howard Gilman titled Free Speech on Campus. And he and I have written a book that Yale University Press will be publishing this summer, again titled Free Speech on Campus. And I'm going to try to condense a quarter's worth of classes and 200 pages worth of material into 6 principles that should guide you as you think about free speech on campus. And then, as was said, I'm glad to take your questions. I regard what I'm saying here as part of a dialogue that we can have today, a dialogue that I hope will continue for months and years to come. But as you participate in this dialogue, I think it's important you know things about the law, particularly with regard to the First Amendment. And I think that's why I'm here for you today. The first of my 6 principles to remember is that the First Amendment applies only to public colleges and universities, though free speech principles should be followed by all colleges and universities. The Constitution, in its protection of rights, applies only to the government. Private entities, including private college universities, don't have to follow the Constitution. Let me give you a couple of easy examples. Before I came to UCI in 2008, I was a professor at Duke University in Durham, North Carolina. Duke is a private university. Imagine while I was at Duke that I had given a speech criticizing the president of the university. Or I guess I should say, imagine when I was at Duke, I again gave a speech criticizing the president of the university. And imagine that he would order me fired because of giving that speech. I could not sue him or the university for violating the First Amendment. The First Amendment applies to government institutions, not to private ones. But imagine I were to give a speech now criticizing the president of the University of California, Janet Napolitano. And imagine she would order me fired. I could sue. In fact, you're my witnesses. I would sue. Since this is a public university, the First Amendment applies. My other example comes from a true story, a conversation I had with my oldest 2 children, trying to calculate how many years ago, because they were 9 and 6 at the time, and now they're 34 and 31. So it was a long time ago. What was occurring then was Diet Coke was giving away free baseball cards, and 3 were pictured on the outside of the package. It was an up and down the aisles of the grocery store. My 2 sons, who were then 9 and 6, were fighting over who was going to get the extra baseball card. Finally, I said, "Be quiet. I don't want to hear anything else about baseball cards till we leave the grocery store." My then 9-year-old turned to me and said, "You can't tell me to be quiet. I've got freedom of speech." I was ready for him. I said, freedom of speech means that the government can't tell you to be quiet. I'm not the government, so I can't. To which he, without missing a beat, turned to me and said, well, you're like the government to me, so you shouldn't really tell him to be quiet. It's a true story. It's when I first knew that someday he was going to go to law school. And in fact, now he's a federal prosecutor in Los Angeles. But the point of both of these examples is something that's very important, one of those basic principles of constitutional law. The rights in the Constitution apply to the government, not to private entities. But I deeply believe that private colleges and universities should also obey principles of freedom of expression, not because it's constitutionally required, but because it's essential to academic freedom. The very core of academic freedom for faculty, for students, for staff is inquiry. There has to be the ability of faculty members in their research and scholarship to express all ideas. There has to be the ability of students in their class on campus to express all ideas. Academic freedom cannot exist without freedom of speech. And I believe integral to the very existence of a college or university is that academic freedom. Well, that leads me to the second principle, and that's that all ideas, all viewpoints can be expressed, no matter how offensive. Perhaps the most basic aspect of freedom of speech under the First Amendment and academic freedom is that there's no such thing as a false idea. There's no such thing as a false viewpoint. The Supreme Court long ago said that the best test for ideas is the marketplace of ideas. Justice Oliver Wendell Holmes said this. He drew on the philosopher John Stuart Mill. He said, let all ideas be expressed. The false ones can get refuted. The true ones will survive. Well, that may or may not work. False ideas may come to be accepted. False views may influence people and cause great harm. But what's the alternative to the marketplace of ideas? The alternative would be to let government officials decide what they think is true and false and censor that which they find objectionable. Would we really want to live in a society where the president, any president, could say, this is what I believe, and anybody who expresses other views can be punished? Would we want to be on a campus where the chancellor can say, these are the acceptable ideas, these are the unacceptable ones, and we're going to punish those who express the unacceptable ones? First Amendment doctrine, as articulated by the Supreme Court, is clear. The government never can restrict or punish speech based on the views accepted. It would clearly violate the First Amendment for a city to say, we'll allow pro-war demonstrations in the park, but we won't allow anti-war demonstrations in the park. Or we'll allow anti-abortion speech in the park, but not pro-choice speech in the park. If anything would violate free speech under the Constitution, it's that form of viewpoint restriction. In fact, the Supreme Court has said that generally the government can't restrict speech based on the topic of the message, based on its subject matter. So, for instance, there was an ordinance in Chicago that said there could be no protests in residential neighborhoods unless there were labor protests related to a place of employment. Now, that wasn't a viewpoint restriction. It was based on the topic expressed. But the Supreme Court declared it unconstitutional because the Supreme Court said the government should not be able to restrict speech based on the content. It's too easy for restrictions of speech that seem to be based on subject matter to really be based on viewpoint. What if in the South in the early 1960s, say in Selma, Alabama, they had said, we're not going to allow any speech for or against continuing segregation of the races. Now that seems viewpoint neutral, but we know whose speech would really be restricted. What if a college campus in the late 60s and early 70s said, we'll allow no speech for or against the United States being involved in the Vietnam War? It seems viewpoint neutral, but it's very much still having the effect of restricting speech based on the ideas. And so the Supreme Court has said that above all else, free speech means that the government can't be restricting speech based on the ideas or the views that are conveyed. This includes even very offensive speech is protected by the First Amendment. Ideas and views can be deeply offensive. They can be racist, sexist, anti-Semitic, homophobic. But they're still ideas. They're still views. A relatively recent Supreme Court case made it clear that the government cannot restrict speech on the basis of its offensive quality. The case was Snyder versus Phelps. It involved a small group out of Topeka, Kansas. They're the Westboro Baptist Church. They make it a practice of going to funerals of those who died in military service and using them as the occasion for expressing a vile, anti-gay, anti-lesbian message. Matthew Snyder was a Marine who died in military service in Iraq. The members of the Westboro Baptist Church traveled from Kansas to Maryland for Matthew Snyder's funeral. When they got there, they asked a police officer where they could stand. The officer pointed an area about 1,000 miles away, 1,000 feet away from where the funeral was going to go on. Before the funeral, being 1,000 feet away, they chanted and sang. During the funeral, they were silent, but they held up signs with slogans. That night on the news, Matthew's father, Albert Snyder, saw the footage and he could read the signs. He was extremely upset. He was deeply offended, and he sued the members of the Westboro Baptist Church for what's called intentional infliction of emotional distress and invasion of privacy. A jury, federal court, awarded Albert Snyder $10 million against the Westboro Baptist Church and its members. But the United States Supreme Court, in an 8-1 decision, ruled in favor of the members of the Westboro Baptist Church. Chief Justice John Roberts wrote for the court, and he said, the government never can punish speech or hold speech liable on the grounds that it's offensive, even very deeply offensive. Once we give the government the power to censor messages because it finds those messages to be offensive, there's nothing left of freedom of speech. There's no stopping point to censorship. Now, I know this issue arises on this and other campuses. People might circulate leaflets that contain very offensive messages. They have the right to do so. I know there's preachers that come onto this campus and say very offensive, anti-gay, anti-lesbian messages. They have the right to do so because speech can't be punished on the grounds that it's offensive. It can't be excluded from a public university on that basis. Now, to be clear, just because the university allows such speech doesn't mean that the university is endorsing the speech. The university, of course, isn't supporting or endorsing all of the messages that go on. When I write an op-ed or write an article, that doesn't mean the university is agreeing with it, but I have the academic freedom to say it. Likewise, the campus has to open its grounds to those from outside, including those preachers, who are expressing even vile messages. Well, that brings me to my third point. Freedom of speech is not absolute. There are categories of unprotected speech. Long ago, the Supreme Court recognized that freedom of speech can't be absolute. Again, it was Justice Oliver Wendell Holmes who said, there's no right to falsely shout fire in a crowded theater. And over time, the Supreme Court has identified some narrow categories of speech that's not protected by the First Amendment. This means it's speech that the government can prohibit and punish. If it's unprotected speech, the campus can prohibit and punish it. So, for instance, child pornography is unprotected speech. A person can be punished for having child pornography, even in the privacy of his or her home. Obscenity is unprotected speech. The Supreme Court has struggled for decades about how to define obscenity. Probably the low point in that regard was when Justice Potter Stewart said, "I can't define it, but I know it when I see it." And then the Supreme Court seems to have given up on trying to define obscenity. False and deceptive advertising is speech unprotected by the First Amendment. And perhaps a category that begins to be more relevant for campuses, incitement of illegal activity is speech unprotected by the First Amendment. A campus can punish students. The state can prosecute students if their speech rises to the level of incitement. But the Supreme Court has formulated a legal test for incitement that is very difficult to meet. In Brandenburg versus Ohio in 1969, the Supreme Court said, in order for speech to constitute incitement, there has to be a substantial likelihood of imminent illegal activity, and the speech has to be intended to cause imminent illegal activity. Both of those requirements must be met. There must be a substantial likelihood of imminent illegality, and the speech must be intended to cause imminent illegality. Now, I've gone through the most important categories of unprotected speech. You'll notice what's not on that list: hate speech. Hate speech is speech protected by the First Amendment. This fits with what I said earlier. The government, campuses can't punish speech just because it's offensive. Not that college universities haven't tried in this regard. In the early 1990s, over 350 colleges and universities adopted so-called hate speech codes, saying that certain expression would be punished because of its hateful conduct. Every court to consider a hate speech code declared it to be unconstitutional. Let me tell you some of the leading Supreme Court cases that make clear that hate speech is protected, and then try to explain to you why hateful speech is protected by the First Amendment. An earlier Supreme Court case arose in an area not far where I grew up in Chicago, Illinois. The case arose in Skokie, Illinois, a suburb just north of the city. At the time that this took place, Skokie had a very large Jewish population. It also had a significant population of Holocaust survivors. The American Nazi Party wanted to stage a march through Skokie, Illinois. They chose Skokie intentionally because it was predominantly Jewish. The city didn't want to allow the Nazis to march there. The city said it would cause great emotional distress to the residents, especially the Holocaust survivors. The city said there was a real danger that those in the city might react, even violently, against the Nazi Party. Every court, including the United States Supreme Court, ruled that the Nazi Party had the right to march in Skokie. It's because of what I already said to you. The government can't punish speech just because it's offensive, even very deeply offensive. Another example. The city of St. Paul, Minnesota, adopted an ordinance prohibiting burning a cross or painting a swastika in a manner likely to anger, alarm, or cause resentment. Burning a cross has a very racist, vile history in this country. Swastikas are symbols of Nazi and the genocide that occurred during the 1930s and the 1940s. And the city said, you can't do this in a manner like to anger, alarm, or cause resentment. But in RAV versus City of St. Paul in 1992, the United States Supreme Court unanimously declared this ordinance unconstitutional. The court, of course, acknowledged that it was well intended, but the court said this is still speech that's protected by the First Amendment. One more example. Case called Virginia versus Black from 2003. This involved the state of Virginia adopting a law that prohibited cross burning. One of the attempts to enforce the law was against members of the Klan. They were holding a rally on an isolated farm. The Supreme Court said the government can't prohibit cross burning. The court said, since this was on an isolated farm where there were few onlookers, the speech was safeguarded by the First Amendment. Why? All of this speech is very hurtful. There's no doubt that hate speech, especially on a college campus, makes it much more difficult for those who have traditionally been excluded to thrive. Epithets are really verbal assaults. They cause psychological pain, even physical pain. So why do we protect hate speech in this country? Most European countries will allow the hate speech to be punished, but not here. I think one reason that we don't allow hate speech codes or hate speech laws is the difficulty of defining what we mean by hate speech unprotected by the First Amendment. Any law, any public university campus regulation that regulates speech cannot be vague or overbroad. It must be clear about what's prohibited and what's allowed. But no campus has found a way of defining hate speech that isn't unduly vague and overbroad. To give an example, the University of Michigan, after a series of racist incidents, decided to adopt a hate speech code. And among other things, it prohibited any speech that was demeaning or stigmatizing on the basis of race. But what does it mean to demean or stigmatize on the basis of race? It also prohibited demeaning or stigmatizing on the basis of sex. A sociobiology graduate student said, "My research is all about whether there are inherent gender differences between men and women. I'm afraid that I can be punished on the basis of my findings in research if I find that there are differences between men and women." Others would say that affirmative action is demeaning to minority groups. Would those who advocate affirmative action by implying that they need it in order to succeed be engaged in speech that's stigmatizing on the basis of race? And so, as I say, every court to consider a hate speech code in the United States, including the one from the University of Michigan, has declared it to be unconstitutional, usually on vagueness overbet grounds. Also, I think experience shows that such hate speech codes are much more likely to be used against members of the group they're desiring to protect than otherwise. It's interesting, when the University of Michigan adopted its hate speech code, all of the complaints under it were lodged against minority students who were said to have engaged in hate speech. When England adopted its hate speech law, the first use of it was against a Zionist group. The argument was that in a United Nations resolution, Zionism was a form of racism. And if you look at the experience throughout European countries, so often hate speech laws are used against the very people who we're trying to protect. But I think there's another, even more important reason why hate speech is safeguarded by the First Amendment. And that's, to censor words is to censor ideas. In a very famous case, Justice John Harlan said exactly that. He said, "We can't censor the English language to please the most squeamish among us. If we try to eliminate certain words, epithets, we're also punishing ideas and views. And remember the premise. On a college campus, all ideas and views can be expressed." Well, what are the situations where a college or university can punish speech consistent with the First Amendment? Let me give you a few important examples. One is what are called true threats. And that's not my phrase, it's one the courts have come up with. The Supreme Court has said that a true threat is not speech protected by the First Amendment. The insight behind this is there's no First Amendment right to make a person fear for his or her safety. If the reasonable person would feel physically threatened, physically in danger by the speech, then it's not protected. Harassment is not protected. there's no right to harass others. The law of harassment arose initially in the workplace. Imagine that an employer said to an employee, "Sleep with me or you're fired." Now, if the employer was sued for sexual harassment, it would be no defense to say, "But I was just engaged in speech." Likewise, in the workplace, speech that creates a hostile or intimidating environment is not protected. But it's important to note that in order to be harassment, it generally has to be pervasive. It has to be on the basis of a protected status, like race, sex, sexual orientation, ethnicity, religion. And it generally has to be directed at a person. So let me contrast some examples. There was an incident at the University of California, San Diego, and another incident at Duke University where a noose was hung from a tree. Could the student be disciplined for putting the noose on the tree? No, based on just those facts, because that by itself doesn't count harassment. But imagine that a noose was tacked to an African American student's dorm door. I think that could be perceived as a true threat. I think that would be harassment because it's directed at somebody. And I could certainly talk in more detail about how to draw the line between speech that's protected and speech that's harassment. But if it would cause the reasonable person to feel unwelcome, if it would cause the reasonable person to feel that he or she was subjected to harassment, that's not speech protected by the First Amendment. One more example. There's no First Amendment right to use speech to keep others from being able to speak or be heard. We had an incident here on this campus a number of years ago. You're probably already familiar with it. Ambassador Michael Erwin was speaking at the invitation of a number of groups and departments. When he began his remarks, a student from the Muslim Student Union stood up and shouted so he couldn't be heard. That student was escorted out. As soon as Ambassador Erwin began, another student stood up and shouted so he couldn't be heard. The professor who was presiding, Mark Petrarca, urged the audience to behave in a civil and appropriate manner, said there'd be time for questions. This happened again. Ambassador Erwin left the stage. The Chancellor, Michael Drake, implored the audience to be respectful. Happened another 7 times. And finally, the students who were protesting left. The issue arose immediately. Did the students who stood up and shouted so Ambassador Erwin could not be heard have a First Amendment right to do so? Some said, well, they were just engaged in speech. I wrote an op-ed in the LA Times the week this occurred, wrote an op-ed much later in the Orange County Register that said, there's no First Amendment right to engage in speech that disrupts the ability of other people to speak. You have the right to speak on this campus, but you don't have the right to come into my classroom and shout so I can't be heard. You have the right to go to the city council and protest, but you don't have the right to go into the chamber of the city council and shout so they can't conduct their business. Now, you may know that these students, mostly from here, some from University of California, Riverside, were criminally prosecuted and convicted for the misdemeanor of disrupting a public meeting. I strongly objected to the criminal prosecution. I think that some form of university discipline was appropriate, but I don't think that criminal actions should be brought unless there's a threat to persons or property. Campuses can deal with it otherwise, and that wasn't present here. But it is important to note the more basic principle that there's no right to use speech to silence others. Otherwise, there'd be a heckler's veto, and any unpopular speaker could be silenced. My fourth principle is that campuses and universities can have time, place, and manner restrictions that serve important purposes so long as they leave adequate alternative places for communication. Even when it's speech protected by the First Amendment, that doesn't mean there's a right to engage in it at every moment, in every place, and in every manner. I'll give you an example. A city adopted an ordinance prohibiting trucks with sound amplification equipment from operating in residential neighborhoods at nighttime. The Supreme Court upheld that. The court said the ordinance served an important purpose, tranquility in residential neighborhoods at nighttime, that it was time, place, and manner in its orientation, and it left open plenty of adequate alternative places for communication. A college or university could say that demonstrations and protests aren't allowed in or near classroom buildings while classes are in session. That would be an appropriate time, place, and manner restriction. It serves the important interest of education of the students, and it leaves open adequate alternative places for communication. And so campuses can have free speech zones. They can also have zones where free speech is restricted. I think dormitories on college campuses are particularly important places for time, place, and manner restrictions. Dormitories obviously are a place where people live. Students should be able to have repose, should not be verbally assaulted. But the law is clear here. Any restrictions with regard to speech in dormitories must be content neutral. It can't be based on the view expressed. So if a campus wants to say students can't hang anything in the windows of their dorms, that would be constitutional. That's content neutral. But if a campus were to say no Confederate flags can be put in windows of dorms, that would be unconstitutional because it would then be the campus restricting speech based on its offensiveness or its viewpoint. A campus can say nothing can be put on the outside of the doors in dormitories. Nothing? That's completely content neutral. But they can't say you can post things except that which we find offensive. That would be based on the content of the expression. So time, place, and manner restrictions are permissible. Sometimes these are so that the university can fulfill its mission for education. Sometimes they're for reasons of public safety. And that's what occurred at the University of California, Berkeley. The chancellor there believed, I think reasonably from all we know, that there was no way to assure public safety and allow Milo Yiannopoulos to speak on that evening. Milo Yiannopoulos has the right to speak on the Berkeley campus or this campus or any public university campus. But if there is a time at which it's believed there's just no way to permit that without endangering the safety of others, then that speech can be stopped. And hopefully it's simply postponing the speech to a time when there can even be more security, more assurance that no one's going to be hurt, no property is going to be damaged. The fifth principle is to discuss some concepts that are now much in vogue. Safe spaces, trigger warnings, and microaggressions. You've probably heard all of these phrases. The difficulty is that they're used without precise definitions. Let me take them one at a time. Safe spaces. Of course, I believe that all students in college or university should feel safe. All should feel part of an inclusive learning environment. And there are many things that college universities should do to be sure that all students feel there's a safe space. I very much favor having student unions for minority groups like Black student unions, Latino student unions, gay and lesbian student unions, women's student unions. So there's a place for repose. And we have these types of affinity identity groups within our law school. I try very hard in every class that I teach to make it a safe space so that all students feel comfortable expressing their views and ideas. I feel personally responsible to make sure that every student should be nurtured and feel protected in expressing views and ideas. On the other hand, safe spaces should not be taken to mean that a college or university can punish speech on campus or exclude speech because it's offensive. I have heard some students say, we shouldn't allow someone like Milo Yiannopoulos, or we shouldn't allow those preachers who express anti-gay and anti-lesbian speech, or we shouldn't allow racist speech because it means that others will not feel safe. Safe spaces cannot mean that it's a basis for censoring or punishing offensive speech. Because remember, all ideas, all viewpoints must be expressed, no matter how offensive. Trigger warnings. Trigger warnings are the concept that a professor warns students before covering material that might be offensive and upsetting. I've actually been giving trigger warnings as long as I've been a professor if I'm going to cover material that might be offensive or upsetting to students. When the chancellor and I taught our class on free speech, we began by reading to the students the exact words of the racist, offensive chant from that bus at the University of Oklahoma. We began by saying to the students that this is going to be very offensive, and then we read it to them. I think that it's just human decency to tell people before saying something that might offend them. But I very much object to campuses requiring professors to do trigger warnings. That was proposed at the University of California, Santa Barbara. It was proposed at Oberlin College. What's the difference? Part of academic freedom is the ability of a professor to choose how to best teach his or her class. Sometimes a professor may believe, for educational purposes, it's important that the students hear the offensive speech before they're warned about it. And I respect the ability of professors to make that choice. Also, it would be very hard to define, in a non-vague way, when trigger warnings would be required. So I have no problem with any professor who wants to give trigger warnings, but I think it would violate the First Amendment. It would be impermissible, compelled speech to require that professors give trigger warnings. Microaggressions. Microaggressions are things that are said that offend individuals, but often the speaker is unaware that the speech is offensive. There's so many examples of things that get said. The speaker means no harm or offense, but it is emotionally hurtful, offensive to the listener. And I think campuses need to sensitize students to that which is found to be microaggressions. But this is where education comes in. This is where colleges and universities have the obligation, through orientation, through sessions like this, through other programs, to let students be aware of how those who are different from them might react to speech, to have them see what speech might be offensive. Sixth and finally, it's important to remember that college and university administrators have free speech rights too. Again, to once more quote the late Oliver Wendell Holmes, he said, "The best remedy for the speech we don't like is often more speech." And so when incidents occur on college campuses where there's been offensive racist speech, one of the best responses is more speech by the campus administrators, by the deans. I've seen this work very well. Many years ago, when I was a professor at the University of Southern California, somebody wrote an anti-gay slur on a whiteboard. Rather than try to figure out who wrote that, punish the student, the dean immediately wrote a letter to everyone in the community. The letter was put in everybody's mailbox. That shows you how long ago it was. It was before there was email. And the dean said that what occurred here is inconsistent with the kind of community we want to be. He used the moment for educational purposes to proclaim the type of community to which the law school aspired. And I think in that way, he took an ugly incident and found a way to heal. Now, that didn't eliminate the hurt that especially the gay and lesbian students felt in seeing it there, but it did serve an enormously powerful end. And I can give you examples from across the country where hateful, offensive speech occurred. Campus officials responded with their own speech, and the more speech really made a difference. I realize that you may resist some of what I've said. Your instinct may very well be to say, why can't we just get rid of these epithets on campuses? Why can't we just get rid of the hate speech? And here I would conclude by reminding you, we don't need principles of free speech or the First Amendment to protect the speech we like. We would let that go on anyway. The reason we need to protect freedom of speech is for the expression we detest. The only way that you or I can be sure that we'll have the right to speak tomorrow is to protect the speech that we don't like today. Thank you. I'm glad to take your questions.
So, Erwin, we have a number of questions that were already asked.
Okay.
I think you covered almost all of them.
Oh, good.
But I will ask one question that
Okay.
went in a little bit of a different tangent or direction. Should a group, in determining membership, be able to discriminate against an individual based on the individual's ideas or values?
My answer to that is no. I can hear talk about the law school's policy. I don't know the campus policy. You would know that. The law school has an all-comers policy. Any student group must be open to all students. If it's using school money, if it's using school facilities, any events it puts on must be open to all students. And my view is we are a public university. Our money comes from you as students through your tuition, from the taxpayers. Any group, any event must be available to all. And if you want to have a meeting, if you're law students, and you don't want to invite everybody, do it in your homes. Do it in a restaurant. And of course, you can do then whatever you want. But if you're using our money, our facilities, all comers, students must be welcome and invited.
And that's similar to the campus policy. So that hopefully answers that. There are a few questions here that are kind of specific to campus-wide instances. I'm not sure that you would be the right person for that, but I invite people to come to our program tomorrow at 4 o'clock, and we can address it there. So with that, why don't we open up to individuals in the audience if you'd like to share a question. I'll try to run the mic over, or if, Tamara, if you're loud enough, you can say it.
Hi, Tammy.
I wanted to touch base on that, one of the last points you made about having administrators actually do more talk to kind of address issues that come up. And since my feeling is that's kind of a top-down thing, how can we help encourage, especially senior administrators, to actually engage in that kind of dialogue? Because often on campuses that I've been on, the administrators don't engage in more speech. And so they tend to be more reactive. So when something happens, they kind of react to it, and then it's silent again. Instead of having that ongoing dialogue where students are encouraged to engage in it.
I agree.
Erwin, can you repeat the?
Sure. The question is, let me put it this way and make sure I've got it right. You begin by saying the more speech is more top-down, and that your observation is that campus officials often haven't engaged in more speech. And what can we do to encourage more so they're not simply being reactive? Let me answer each part of what you say. I agree to have campus officials, whether the chancellor or the vice chancellor or a dean respond is top-down. I think it's important that that not be the only way of responding. If there's something that occurs on campus that students don't like, they also can engage in more speech. If the Muslim Student Union didn't like Ambassador Orrin speaking, they should have had a counter demonstration that night or another day. They could have used it to picket. They could have used it to hand out leaflets. They could have used it to bring in their own speakers. That's what I mean by more speech, and that's not top-down. Second, you're absolutely right that too often campuses are reactive. I'll give an example again from the law school. I was worried that we may have been taking for granted, not dealing with problems that existed. So a year and a half ago, I created a committee on inclusion and diversity within the law school, not in reaction to anything that occurred in the school, but precisely because I didn't want to wait until something happened and then react. Ideally, try to prevent problems. We often just don't know what we don't know. We can't experience things other from our own lives. And so people who are different from us, who have different experiences, we often don't hear about them. And it was terrific. They came up with great recommendations. We've been able to implement almost all of them. We've recreated the committee for next year. I don't know if there's similar things on campus, but it's something I'd encourage administrators to do. It's really served our interests well to have this committee on inclusion and diversity. Third, in terms of campus officials, I think Howard Gilman's statement on free speech that he puts out at the beginning of the school year is a wonderful statement. It's maybe the best I've ever read from a campus chancellor or president. I think that the campus needs to look for other occasions. I think there were instances in the past where some racist, anti-Semitic speech was on campus, and perhaps there wasn't as much of a reaction as there should have been. But I'm also sensitive. The campus officials can't respond to every incident because there's a point at which if they speak too much, they're undermining their ability to be effective. It's a matter of picking and choosing, and it has to be done at the moment. And sometimes responding too quickly can be a problem because you don't have all the facts. Sometimes reacting too late is a problem because the incident has already happened and everyone's attention has gone on to other things. But I think that campus officials have a real responsibility. And of course, I mean, again, Howard Gilman has been thinking about these questions of free speech and inclusiveness as much as anybody.
Question.
Thank you. That was fascinating. I have one specific question relating to the Westboro Baptist Church.
Yes.
Protesting at a funeral. Couldn't one argue against their free speech right to do that based on your time, place, and manner dependence?
Yes, there can be restrictions on the question. Oh, you got the microphone. There can be restrictions on where they speak, so long as it leaves adequate alternative places for communication. So in this instance, they said to the police officer, "Where can we be?" And the police officer said, "You can be this 1,000 feet away." Would 2,000 feet away have been okay? Sure. Would saying, "Come back tomorrow" have been okay? No. Would say, "Go to the city that's 50 miles away" be okay? No, that wouldn't be either. So yes, you can restrict where it is to make sure that they're not interfering with the funeral service itself. You can restrict how they go about it to make sure they don't interfere with the funeral service. But in this instance, what was really the basis for liability was their silent protest that didn't disrupt the funeral service. And the Supreme Court held emphatically that couldn't be the basis for liability.
All right, I think this might be our last question.
Hi, thank you for that. I'm wondering if you might be able to talk a little bit more about what a reasonable person is, because it seems like what hate speech does or can do may not feel, may not be harassing me or intimidating me, but it might somebody else, right? So I don't know what a reasonable person is.
I want to say two things. One is the idea of a reasonable person appears throughout the law. So it's not unique to this area. And I think you have to look at it from the perspective of the victim. So if it's in the context of sexual harassment in the workplace and it's a woman who's subjected to it, it has to be looked at from the perspective of the reasonable woman. If we're talking about on the perspective of the college campus, again, you need to focus as much as it's humanly possible from the perspective of the victim. But the second thing that's important is just because a reasonable person might feel harassed by the speech doesn't make it harassment that is not protected by the First Amendment. And so harassment, already unprotected by the First Amendment, generally has to be, not always, pervasive. It has to be directed at somebody. It has to make the reasonable person feel unwelcome in the environment and the like. So let me give you an example. You might have heard of a student at UCLA who posted on YouTube a very offensive anti-Asian rant. No matter how much that may have made Asian students uncomfortable there, that's not harassment. Now, if that same student had every day yelled at Asian American students that were crossing his campus, then that can rise to the level of harassment. Or it's my example, putting a noose over a tree is enormously hurtful. It can make African American students on campus feel threatened, but it's still protected by the First Amendment. Tacking a noose on somebody's door, That's harassment. The students who chanted on the bus at the University of Oklahoma, what they said was vile, but it was speech protected by the First Amendment. On the other hand, if they repeatedly yelled those same things at African American students on campus, that could rise to the level of harassment. So, got to be careful that the reasonable person is part of the test for harassment, but it's not the only part of the test for harassment.
All right. With that, I want to thank Dean Erwin Chemerinsky for his talk today. Amazing job as always.